The First Amendment's religion clause seems to pull us in two different directions. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. These two clauses seem to protect two different rights, not one general right. As we'll see, the application or enforcement of one of those rights can often implicate the other. Guaranteeing one's free exercise rights, for example, can sometimes put the government in a position where it seems that it's promoting one religion over another. The United States has a unique history with respect to religious freedom. As many of you already know, many of the first Americans to arrive at our shores did so to escape religious persecution elsewhere and ensure religious freedom for themselves and their families. However, some of those same groups also immediately began to prosecute and punish those who did not conform to their particular religious beliefs. In fact, many colonies, and then states, had official religion and required universal participation, even sometimes tying that participating to voting requirements. To be sure, there were exceptions, like Roger Williams, who fled to Rhode Island, that do represent a strong dissenting tradition in American history. These differing histories mean that even to this day, we still disagree about the origins and intentions of those who wrote the clause. As we'll see, these histories, often selected by justices and others in a way that supports their own preferred outcomes in these cases, are an important development of establishment jurisprudence on the court. We should also note that next to the Free Speech Clause, the Establishment Clause is one of the earliest clauses to be incorporated or applied against the states. This adds another layer on top of establishment jurisprudence. Not only is it difficult to give exact meaning to what establishment means, but the added dimension of federalism further complicates the matter. Maybe establishment should be applied or incorporated against the states, but maybe states should allow for some variation in their ability to deal with religion. As we study these cases, it's important to keep in mind that one of our goals in this course is not only to understand these ideas as constitutional and legal ones, but also as historical concepts. This means that we need to pay attention to the different and changing ways that the court will interpret the clauses we study, and establishment is no different. As you read, you'll see three distinct periods of development or change that characterize the overall decisions of the court in establishment cases. After the clause is incorporated against the states in 1940, we see that during the 1940s and 50s, the court adopts what is called strict separation. This means that states will not violate the Establishment Clause if their policies are neutral toward any one religion and if these policies are for secular purposes. However, there can be some indirect benefits that religion can enjoy. We'll see this in the Everson case involving state support for school busing for parochial school students in New Jersey. It is during this period, moreover, that the court announces that it will use Thomas Jefferson's wall of separation metaphor as a guiding historical justification for its Establishment Clause cases. But in the 1960s, the Warren Court will adopt an even more restrictive stance. Here, states will not run afoul of the Establishment Clause if their policies are neutral and secular, but there can be no direct or indirect benefits flowing to religion. This will be the high water mark for what some call the court's disestablishment jurisprudence. In cases like Engel versus Vitale, for example, prayer in schools is deemed to violate the Establishment Clause. Cases like this, and especially the court's approach to them, have been controversial ever since. Finally, from the 1970s to today, the court has adopted what we call a more accommodationist approach. There still needs to be a secular purpose behind state policies and regulations, but aid and benefits to religion are permitted in some cases. Since the 1970s, moreover, the court has developed tests to determine the conditions under which state policies and regulations violate the Establishment Clause. The tests are designed by the court to help them decide in a seemingly neutral way such an important issue, such as establishment. We'll see the court move from a secular purpose, secular effects test to a test called the Lemon Test, from a case in the early 1970s that added another requirement beyond secular purpose and secular effect to try and accommodate religion, which was that the policy in question cannot foster, quote, an excessive entanglement between government and religion. Over the last few decades, though, some in the court have utilized the Lemon Test, but others have not. Some have even added more tests, like whether a prayer at a high school graduation might psychologically coerce students, thus violating the Establishment Clause. So So as you read, think about, and critique the Establishment Clause cases, think about the following questions. Which approach, if any, that the court has taken makes the most sense to you? Should the government and the court even be involved in Establishment Clause issues beyond simply refusing to support one religion or church over another? Which test, if any, developed by the court seems to best understand and enforce the Establishment Clause? Could you develop a neutral test for determining when state policies, laws, and regulations run afoul of the Establishment Clause? And finally, does government involvement with religion, no matter how small and seemingly innocuous, have the potential to hurt both government and religion?